hearing, Bill of Particulars, and the gag order. United States of America v. Sean Combs. Case number 24-542. Preliminary statement. The government respectfully submits its response to the series of motions filed by defendant Sean Combs since he was indicted by a grand jury sitting in this district a little more than a month ago. His motion for an evidentiary hearing, among other relief, in response to purported leaks, his motion to require the government to identify victims, and his motion for an order prohibiting extrajudicial statements from civil litigants. First, the court should deny the leak motion for the simple reason that the defendant fails to show the leak grand jury material. Any factual basis, the leak motion seeks to suppress probative evidence, a video of Combs brutally physically assaulting a victim in March of 2016 that was published by a media outlet in May of 2024 by was grand jury material leaked by agents to CNN. But as the defendant is fully aware, the video was not in the government's possession at the time of CNN's publication, and the government has never, at any point, obtained the video through grand jury process. The defendant also complains about purported law enforcement sources leaking other alleged grand jury materials to the media in several news articles cited in his papers and set forth in the attached table. Here, too, the defendant is grasping at straws. Because the defendant cannot show that the information in the cited articles is grand jury material, and because he cannot show the government agents with access to grand jury material leaked the information, he cannot make the prima facie showing required for relief he seeks. Moreover, even if an information in the cited articles could be considered non-public information improperly disclosed, the defendant's request for relief under Local Criminal Rule 23.1 is mooted by the order entered by the court on October 25, 2024. Second, the court should reject the defendant's Bill of Particulars motion as not only unnecessary, but improper. As an initial matter, the defendant has been more than sufficiently apprised of the charges he faces, including through a 14-page speaking indictment, the government submissions and statements on the record in connection with the defendant's bail hearings, and significant production of discovery. And at the appropriate time, in accordance with the well-established practices in this district, the defendant will receive even more disclosures about the conduct with which he is charged, including through additional discovery, an enterprise letter, a witness and exhibit list, and Janks Act material. Accordingly, the defendant cannot credibly claim that he will suffer unfair surprise at trial. Rather, it is plain that the defendant's request for a Bill of Particulars containing victim names is merely a vehicle to attempt to prematurely restrict the government's proof at trial and use the criminal proceedings to defend himself in the press against complaints in separate civil litigations. The improper request should be denied in its entirety, particularly here, where there are serious and ongoing concerns for victim and witness safety, tampering, and intimidation. Finally, the victim gag motion should be denied as an attempt to backdoor the federal rules of criminal procedure to compel the government to prematurely disclose its witness list. Indeed, by seeking a preemptive gag order under Local Rule 23.1, preventing potential witnesses in the criminal case and their counsel from making extrajudicial statements, the defense is essentially asking for either a blanket order that would apply indiscriminately to any individual with claims against Combs and their lawyers, or for a more limited order that would require the government to identify its witnesses 6 months before trial. Not only would such relief be unprecedented, but the defendant should not be permitted to use local criminal rule as a sword to gag civil claimants, whether or not their statements were connected to his criminal proceeding or to evade established case law in this circuit. Procedural history. In or around November 2023, and as described in more detail below, federal prosecutors from the United States Attorney's Office for the Southern District of New York, working with case agents from the Human Trafficking Squad of the New York Field Office of Homeland Security Investigations, began investigating Combs and others for violation of federal criminal law. On September 12, 2024, a grand jury returned a 3-count indictment charging defendants with racketeering, conspiracy, and violation of U.S. Code 18, Section 1962D, Count 1. Sex trafficking by force, fraud, and coercion in violation of U.S. Code Section 1591 A and 1, B1, 1594 A. and 2, count 2, and transportation to engage in prostitution in violation of U.S. Code 18, Section 2421A, and 2, count 3, as alleged in detail in the 14-page speaking indictment. Starting in at least 2008, the defendant participated with others in a racketeering conspiracy that he led and controlled the Combs Enterprise. The defendant and other members and associates of the Combs Enterprise wielded the defendant's power and prestige in the entertainment industry to cause female victims to engage in extended sex acts with male commercial sex workers, referred to as freak-offs, which defendant directed, masturbated during, and often electronically recorded. The Combs Enterprise accomplished its goals through acts of violence and obstruction. With respect to the freak-offs, the defendant threatened victims with the electronic recordings of sex acts as collateral. In addition, the defendant physically assaulted women and others by striking, punching, dragging, throwing objects at, and kicking them. Members and associates of the Combs Enterprise also, at times, carried firearms, and on more than one occasion, the defendant carried or brandished firearms to intimidate and threaten victims and witnesses of his crimes. Further, when the defendant's power was threatened, the Combs Enterprise engaged in acts of violence, including kidnapping and arson, and pressured witnesses and victims, including through attempted bribery, to stay silent and not report what they experienced or knew to law enforcement. On phone calls, the defendant and other members and associates of the Combs Enterprise, among other things, provided these victims and witnesses with a false narrative of events in an effort to conceal the defendant's crimes. Following the return of the indictment by the grand jury, Combs was arrested on September 16, 2024. The next day, on September 17, 2024, United States Magistrate Judge Robin Tarnowski ordered the defendant detained pending trial. United States District Judge Andrew Carter, to whom the case was then assigned, held another bail hearing on September 18, 2024, after which he ordered the defendant remain detained pending trial. In reaching his determination, Judge Carter stated that the defendant is a danger regarding obstruction of justice and witness tampering, and a danger to the safety of others in the community more generally. In the last month, the defendant has filed multiple applications for relief from the court, each one insisting that the relief sought was necessary and urgent. On October 9, 2024, the defendant filed the leak motion seeking various forms of relief, including an evidentiary hearing, discovery, a gag order, and suppression of evidence. Then, on October 15, 2024, the defendant filed the Bill of Particulars motion pursuant to Federal Rule of Criminal Procedure 7F, asking the court to require the government to identify the victims in the case more than 6 months before the trial. Finally, on October 20, 2024, the defendant filed the victim gag motion related to media statements from civil plaintiffs and their attorneys, seeking an order prohibiting prospective witnesses and their counsel from making extrajudicial statements, among other relief. Background: the investigation of the defendant. Together with case agents from HSI-NY federal prosecutors from the USAO SDNY, commenced their investigation into the defendant and others in November of 2023. As part of the investigation and pursuant to the authority of the grand jury issued subpoenas to obtain evidence, including documents and other records, as well as witness testimony. To date, the grand jury has issued over 300 subpoenas, and the government has interviewed over 50 witnesses, several of whom testified before the grand jury. The government also took other investigative steps outside the grand jury process, including obtaining a multitude of judicially authorized search warrants for, among other things, searches of cloud storage accounts governed by the Stored Communications Act, U.S. Code 18, Section 2701, and searches of certain premises, persons, and electronic devices in accordance with Rule 41 of the Federal Rules of Criminal Procedure. 1. Grand jury materials. The grand jury investigation of the defendant proceeded in accordance with Rule 6 of the Federal Rules of Criminal Procedure, which governs, among other things, secrecy of matters before grand jury and materials considered by the grand jury. For the purpose of this motion, the government attorneys, analysts, and law enforcement agents who have access to Rule 6E materials are referred to herein as the prosecution team. Throughout the investigation, and in accordance with Rule 6, the grand jury issued subpoenas for various records relevant to the investigation, including inter alia, hotel records, travel records, financial records, and phone records. The records returned in response to those subpoenas were maintained pursuant to Rule 6E. At both HSI-NY and the USAO SDNY, access to the repository of electronic files containing grand jury information is restricted to the prosecution team. Specifically, at HSI-NY, only the assigned HSI-NY agents can access all of this grand jury material, and if an unauthorized individual attempted to query or access the case file would appear to be empty to the unauthorized agent. In addition, the lead case agent would receive a notification to identify the unauthorized agent who attempted to access the case file. 2. March 25, 2024, search warrants. The government's investigative steps outside the grand jury included numerous judicially authorized search warrants, including multiple warrants executed on March 25, 2024, in Los Angeles and Miami. Specifically, HSI-NY, with the assistance of agents from local field offices, executed search warrants on March 25, 2024 at 3 locations: the defendant's Miami Beach residence, the Miami house, the defendant's Los Angeles residence, the LA house, and on the persons of the defendant and his chief of staff at the Miami Apalaca Executive Airport, the airport. Each of the search warrants executed on March 25, 2024 was authorized by magistrate judges in the Central District of California and the Southern District of Florida, who reviewed sworn affidavits, setting forth probable cause for each of the searches, the affidavits, before signing each respective search warrant. Each search warrant consisted of the warrant signed by the magistrate judge, followed by attachments describing the property or persons to be searched and the items to be seized. The search warrants to be executed at the airport and the Miami house authorized execution between 6 a.m. and 10 p.m., while the LA house warrant authorized execution at any time of the day or night, as it was meant to be executed simultaneously with the warrants at the airport and the Miami house. The airport search, which was conducted after the defendant and others boarded a private plane bound for the Bahamas, began first on March 25, 2024, and dictated the timing of the execution of the search warrants at the Miami house and LA house. At both the Miami house and LA house, an HSI special agent served as the team leader, and multiple agents assisted in performing the searches. The team leader at each location had a copy of the applicable search warrant to leave at the location of the search, as required by Federal Rule of Criminal Procedure 4F1C. No copies of the affidavit setting forth probable cause were taken or left at any search location. The team leader at each location also prepared an inventory of items seized pursuant to Rule 41F1B, which was left at each premises alongside the team leader's copy of the search warrant. B. Discovery. Since the defendant's arrest a little over a month ago, the government has made 3 significant productions of discovery material, which include the following categories of materials: all search warrants and supporting affidavits, hotel, financial, and communication records produced pursuant to the grand jury subpoenas, and electronically stored information from over 60 of the defendant's own devices and iCloud accounts, including, among other things, text messages, audio and video recordings, photographs, and documents, which the defendant had requested to be prioritized. These materials contain additional details about the allegations against the defendant, including, for example, specific allegations relating to multiple victims in search warrant affidavits and communications with victims and witnesses from the defendant's devices. Forthcoming discovery will similarly contain additional details about the alleged conduct, including additional communications with victims and witnesses, travel and hotel records relating to freak-offs, bank records showing payments to victims by the defendant, and entities associated with the defendant, and police and fire department records to the kidnapping and the arson discussed in the indictment. The argument. Under the law in the circuit, all 3 defendants' motions should be denied in their entirety. First, with respect to the leak motion, the defendant has not made a prima facie showing of any leak of grand jury material. Consequently, the defendant requests for inter alia an evidentiary hearing, and the suppression of a video showing the defendant violently assaulting a victim must be rejected. Second, the defendant's demand for a bill of particulars identifying victims in the case fares no better because his request, made well before the conclusion of discovery, is both premature and without merit. Finally, the defendant's request for what amounts to a witness gag order should also be denied because it was nothing more than another attempt to force the government to prematurely disclose its witness list and/or demand extraordinarily overbroad relief. 1. The defendant is not entitled to the relief he seeks for purported leaks. In the leak motion, the defendant argues, baselessly, that a video depicting the defendant's assault of a victim at the Intercontinental Hotel in Los Angeles on March 5, 2016, the Intercontinental video, was provided to the media outlet by government agents. The leak motion also catalogs alleged non-public information purportedly provided to media outlets by government sources in multiple news articles. However, the defendant cannot demonstrate that disclosure of any of the information in the cited articles, including the Intercontinental video published by CNN, was subject to the secrecy protections of Federal Rule of Criminal Procedure 6E, or that any such disclosure came from any member of the prosecution team. Accordingly, it is not entitled to relief. Applicable law: Federal Rule of Criminal Procedure 6E and grand jury secrecy. The proper functioning of our grand jury system depends upon the secrecy of grand jury proceedings, because absent that secrecy, prospective witnesses may be deterred from testifying. Those who do testify may be less likely to do so truthfully. Targets of investigations may flee, and persons who are the subject of an ultimately meritless investigation may face public embarrassment. United States v. Haller, 837 F.2D, 84, 87 and 88, 2nd Circuit, 1988. Rule 6E governs disclosure of grand jury proceedings and provides that an attorney for the government and any government personnel to whom grand jury material has been disclosed may not disclose a matter occurring before the grand jury. The core of what Rule 6E2 protects is evidence that is actually presented to the grand jury, but the protection also extends beyond the literal evidence that is presented to include anything that may tend to reveal what transpired before the grand jury, such as summaries of grand jury testimony. United States v. Skelos, 15 CR.317, KMW 2015 WL 6159326 at 9, SDNY, October 20th, 2015. Quoting United States v. Eastern Airlines Incorporated, 923 F.2D 241-244, 2nd Circuit, 1991. The rule is intended only to protect against disclosure of what is said or what takes place in the grand jury room. United States v. Interstate Dress Carriers Incorporated, 280 F.2D 5254, 2nd Circuit, 1960. The rule also does not apply to disclosures of information obtained independently of the grand jury process, even if the same information might later be presented to the grand jury. Skelos, 2015, WL 6159326 at 10. When the government gathers information outside of the grand jury through wiretaps, search warrants, and interviews with witnesses not expected to appear before the grand jury, that information is not subject to Rule 6E provisions on disclosure. See also Eastern Airlines 923 F.2D at 244. Rule 6E, not violated by disclosure of search warrant, affidavits, even if information from affidavit might later be presented to the grand jury. Where a defendant claims that grand jury matters were disclosed in must first establish a prima facie case of a violation. United States v. Rue, 97 F.3D 648 662, 2nd Circuit, 1996. To determine whether the defendant is made out a prima facie case, the court should examine, among other factors, 1. Whether the media reports disclose matters occurring before the grand jury. 2. Whether the media report discloses the sources as one prohibited under Rule 6E. And 3. Evidence presented by the government to rebut allegations of a violation of Rule 6E. See also United States v. Skelos, 988 F.3D 645, 662, 2nd Circuit, 2021. United States v. Blasak, 17 CR 357, LAK, 2018 WL 1322 192, at 3, SDNY, March 12, 2018. In the second prong, the sources prohibited under the rule include, as relevant here, an attorney for the government and law enforcement agents to whom grand jury disclosures are made under Federal Rule of Criminal Procedure 6E3A2. United States v. Walters 910 3.D 1119, 2nd Circuit, 2018. See also Skelos 988 F.3D at 662. Distinguishing between a government source or law enforcement sources cited in articles and government investigators subject to Rule 6E, where the sole direct evidence of Rule 6E violation, media reporting, courts evaluate whether the reporting itself contains protected grand jury information, because if the article contains no information of the sort Rule 6E protects, then no prima facie case can be made out. Blasak, 2018 WL 1322 192 at 3 and 30. According to United States v. Nordlicht, 16 CR 640 BMC 2018 WL 6106707 at 3 EDNY, November 21st, 2018. 2. Local Criminal Rule 23.1 and non-public information. Separately, Local Criminal Rule 23.1, entitled Free Press, Fair Trial Directives, sets forth restrictions regarding the release of non-public information or opinion and making extrajudicial statements pending criminal cases and investigations. Specifically, the local rule provides, it is the duty of the lawyer or law firm and of non-lawyer personnel employed by a lawyer's office or subject to a lawyer's supervision, private investigators acting under the supervision of a criminal defense lawyer, and government agents and police officers not to release or authorize the release of non-public information or opinion that a reasonable person would expect to be disseminated by means of public communication in connection with pending or imminent criminal litigation with which they are associated. If there is a substantial likelihood that the dissemination will interfere with a fair trial or otherwise prejudice the due administration of justice. Local Crim R 23.1a. And with respect to a grand jury investigation, participating lawyers, including lawyers for the government and lawyers for targets, subjects, and witnesses, are directed to refrain from making any extrajudicial statements that a reasonable person would expect to be disseminated by means of public communication that goes beyond the public record or that is not necessary to aid in the investigation, so long as the dissemination will interfere with a fair trial or otherwise prejudice the administration of justice. Local Crim R. 23.1b. The court has the authority to prevent violations of Rule C. United States v. Con. 538 F.SUPP 2D 929 931 EDNY 2007, but must consider whether the order will be necessary to ensure an impartial jury and must find that less extreme available remedies, singly or collectively, are not feasible or would not effectively mitigate the pretrial publicity and bring about a fair trial. Local Crim R 23.1H. In addition, any lawyer who violates the terms of Local Criminal Rule 23.1 may be disciplined under Local Civil Rule 1.5, Local Crim R. 23.1.I. B. The discussion. The defendant is not entitled to the remedies he seeks, including suppression of evidence at an evidentiary hearing, because he has failed to make a prima facie showing that 1. There has been disclosure of a matter or a matter is occurring before the grand jury, and 2. That the source of the disclosure was an attorney or agent of the government. Skelos, 2015 WL 6159326 at 9. 1. Intercontinental video was neither grand jury material nor leaked by the prosecution team. At the forefront of the leak motion is the defendant's bald attempt to suppress a damning piece of evidence against him, a video of him violently beating a victim at the Intercontinental Hotel in Los Angeles in March of 2016, under the guise of grand jury secrecy. As the defendant well knows, The intercontinental video publicly released by CNN was not in the possession of the government at the time of its publication and has never been a record obtained through grand jury process. Nonetheless, in the leak motion, the defendant baselessly accuses DHS agents, who have no authority to issue grand jury process, of secretly obtaining the intercontinental video unbeknownst to the prosecutors conducting the investigation and then leaking it to CNN. No evidentiary hearing is necessary to reject these assertions as incredible. As alleged in the indictment, the intercontinental video was publicly reported by CNN captured one instance at a Los Angeles hotel in or about March 2016, during which Combs kicked, dragged, and threw a vase at a woman as she was attempting to leave. Indictment at 4. From early in the investigation, the government pursued obtaining video of this assault and investigated the circumstances under which the surveillance video disappeared from the hotel's server shortly after March 5, 2016. See September 17, 2024 at 13, describing the defendant's attempt to bribe a security guard, direction to his staff to contact hotel security staff, and surveillance video disappearing from hotel server within days of March 5, 2016. September 18, 2024 TR at 10 and 11, same. The government ultimately obtained the intercontinental video at the same time as the general public on May 17, 2024, when CNN publicly released the footage. The morning that CNN released the intercontinental video, counsel for the defendant contacted the prosecutors assigned to the case to alert them that CNN had the video and expressed a concern that someone, not any of you, and not the lead case agents, provided this footage to CNN. Just after 1 p.m. that day, a government analyst alerted the prosecutors that CNN had published a story about the assault, including the hotel surveillance video, which the analyst preserved by screenshotting the CNN online article and downloading the associated video. The metadata associated with the government's copy of the intercontinental video indicates that the file was saved on May 17, 2024. That is, when it was downloaded from CNN. Prior to that date, the government had been unsuccessful in obtaining any video of the assault. And still, as of the date of the filing of this brief, the government has not obtained the intercontinental video broadcast by CNN from any source other than the public broadcast. Accordingly, any claim by the defendant that the intercontinental video is grand jury material is flatly wrong, and the defendant was well aware of this fact at the time he filed the leak motion. Indeed, prior to filing the motion, the government advised defense counsel by email that it possessed no surveillance video from the Intercontinental prior to CNN's public broadcast, and that it had obtained the Intercontinental video through CNN's public airing, not through a grand jury subpoena. The government likewise informed defense counsel of its understanding that HSI, New York, which cannot independently issue grand jury subpoenas, similarly did not have possession of the Intercontinental video prior to CNN's broadcast. Desperate to suppress the evidence anyway, the defendant makes the ipse dixit argument that it is reasonable to believe that the Intercontinental video was obtained in connection with a grand jury investigation. The defendant's reasons, for example, that government agents must have been responsible for the leak because, among other reasons, the day that CNN decided to publish the video was a slow news day, given the break-in in the Trump trial. But it's strange credulity to suggest that law enforcement agents independently obtained the Intercontinental video with a grand jury subpoena they had no authority to issue. The defendant refuses to acknowledge that multiple individuals other than government agents, including some of his own employees, may have had access to the Intercontinental video. Indeed, the government is continuing to investigate who had access and who may have obtained the video, including, for instance, employees of the hotel, the security team, contracted by the hotel, and members of the defendant's staff, who, as discussed on the record, attempted to obtain the video surveillance after the incident in March of 2016. Any of these individuals could have provided the Intercontinental video to CNN, but bald speculation is not a valid basis from which to conclude that there was a law enforcement leak of grand jury information. The defendant thus falls far short of establishing a prima facie case of Rule 6e violation as to the Intercontinental video. Likewise, the defendant cannot plausibly establish that the Intercontinental video was a non-public information that the USAO, SDNY, or its agency partner had in their possession at the time of CNN's publication. Therefore, to the extent that the defendant could seek any relief under Local Crim R 23-1 for such a disclosure, no relief is available here. 2. The defendant fails to establish that the cited articles disclose matters occurring before the grand jury. While the clear objective of the leak motion is to suppress the intercontinental video, the defendant also complains about other leaked information in the cited articles. However, as with the intercontinental video, the defendant's categorization of much of the information in the cited articles as material protected by Rule 6E is entirely speculative and has no basis in fact or common sense. The searches of the defendant's Miami house and LA house and evidence recovered therefrom are the subject matter of the majority of the cited articles. The defendant has not and cannot establish that this information is protected grand jury material because the law is clear that information obtained through search warrants is outside the scope of Rule 6E's protection. The defendant's argument that disclosure of information about the searches, including the target of the investigation, the type of search warrant obtained and materials sought, and evidence obtained pursuant to search warrants, somehow reveals the nature or direction of the grand jury proceedings. Leak Motion 14, quoting Grand Jury Subpoena 103 F.3D at 238, is undermined by the very authority the defendant cites. Courts in most circuits, including the Second Circuit, have held that Rule 6E is not violated by the disclosure information obtained by a criminal investigation that parallels but is independent of a grand jury investigation, such as information and material obtained by search warrant. See Grand Jury Subpoena 103F.3D at 238 and 39, citing cases holding that when information is produced by a criminal investigation that parallels but is independent of a grand jury investigation, disclosure of the information is not a violation of grand jury secrecy because it is not a matter occurring before the grand jury. Even if the cited articles include arguably non-public information obtained from the searches, disclosure of this information does not constitute a violation of Rule 6E. See Nordlick 2018 WL 6106707 at 4, finding no violation of 6E when information published in new articles was contained on the face of the search warrant and its attachments and search was executed prior to the publication of the news articles. Skelos 215 WL 6159326 at 10, finding no violation of Rule 6E when disclosures of information could have been discovered in the course of a grand jury investigation or an investigation outside the grand jury based on materials obtained through wiretaps, search warrants, and interviews with witnesses not expected to appear before the grand jury. Simply put, the defendant cannot show that disclosure of information obtained from the searches violates Rule 6E. The information in the cited articles beyond that obtained pursuant to search warrants is similarly unprotected by Rule 6E. For instance, the defendant complains about the cited articles disclosing witness meetings with the government. 4 Jane Does and 1 John Doe already sat for interviews with Southern District of New York investigators for a probe related to alleged sex trafficking and racketeering, and more interviews are scheduled. Prosecutors have interviewed a number of Diddy's accusers, including those who have filed civil lawsuits. But those cited articles do not identify the witness as grand jury witnesses, nor do they reference testimony before the grand jury. Mere speculation by the defendant that the individuals were grand jury witnesses does not establish prima facie violation of Rule 6E. CEG Blaylock 844 F.2D at 1551, no violation of Rule 6E based on disclosure of interviews that occurred outside of the grand jury. Nordlake 2018 WL 6106707 at 4. To violate Rule 6E, there must be improper disclosure of the inner workings of the grand jury, not simply information about some aspect of a related government investigation. 3. The defendant cannot show that the prosecution team was the source of any improper disclosures. Moreover, none of the cited articles indicate, on their face, that any leaked information came from the government attorneys or members of the prosecution team, i.e. the prosecutors and agents conducting the investigation who had access to grand jury material. Even in the articles that attribute information to law enforcement do so vaguely, citing law enforcement sources, see docket number 32, 32.2, 32.3, 46, 10/15/2024 article or sources familiar with the investigation. Some of the cited articles simply cite sources or quote previously published articles or reporters to meet the burden of prima facie showing a far more explicit connection between the alleged leak and law enforcement officers conducting the investigation is required. CEG Barry v. United States, 865 F.2D 1317, 1325 D.C. Circuit, 1989. Multiple articles sourced to law enforcement officials with knowledge of particular testimony given to a grand jury. When the sourcing is less clear, courts are reluctant to draw the conclusion that the defendant leaps to hear that anonymous sources close to or familiar with an investigation must be the personnel conducting that investigation. See Blasak 2018 WL 1322192 at 6. Neither the article's attribution of sources, unspecified people familiar with the probe, nor its substance sufficiently points to the government. None of the news articles or the letter indicate that the government attorney or agent was the source of the information, and at least one explicitly states that the U.S. Attorney's Office and FBI representatives declined to comment. Further, even when reporters expressly cite law enforcement or government sources, the Second Circuit has refused to infer lightly that those sources were members of the prosecution team. See Scalos 988 F.3D at 662. The media outlets only identified a government source, or law enforcement sources, not government investigators. Even taking at face value that the alleged law enforcement sources are indeed individuals who work in federal law enforcement, which is not a given, as many of the articles contain vague attributions, the defendant's logical leap that those sources must be attributable to the government personnel who have access to 6E material finds no support in the case law. See also Nordlich 2018 WL 6106707 at 4. Finding that the defense allegations that government agents were the sources of the disclosures based on the terms used in the cited articles, described unnamed sources such as persons with direct knowledge of the matter, briefed on the investigation, and not authorized to speak publicly on the matter, did not warrant the conclusion that the sources in the cited articles were government agents or government attorneys. Moreover, even as information sourced vaguely from federal law enforcement or something similar, the information discussed in many of the cited articles was not known only or even principally by the prosecution team. For instance, the cited articles about the searches of the defendant's Miami house and LA house contain information that could be gleaned from the material left in those residences following the searches, including the search warrants themselves, as well as the attachments to the search warrants and search warrant inventories. The recipients of those materials, presumably individuals associated with the defendant who have no ties to the prosecution team, were free to share those materials with anyone they chose, including the defendant, members of the defendant's staff, and other individuals, including the press. Likewise, with respect to the government's meetings with witnesses, multiple parties other than the government are aware of instances in which the government meets with witnesses, including the witness themselves, counsel for the witnesses, and any other individuals the witnesses may choose to tell about the meeting. Any of those individuals, none of whom is within the government's control or covered by Rule 6E, could elect to disclose the meeting. The same goes for information requested by grand jury subpoena. Recipients of documents requested via grand jury subpoena are not bound by the secrecy requirements of Rule 6E. Therefore, where hundreds of grand jury subpoenas have been issued to third parties, leaked information from sources close to the case about documents and information sought by grand jury subpoena are just as likely to have come from recipients of those subpoenas. Even information in the cited articles sourced generally to law enforcement cannot meaningfully be linked to the prosecution team here. For example, in one article cited by the defendant in his October 20th, 2024 letter, a law enforcement source with knowledge of the case is quoted as saying, "This is all but shaming the alleged victims. It's part of the defense, offensive course of action. They'll try anything." This purported law enforcement source could be anyone who read the publicly available transcripts of the bail hearings, in this case, or anyone who viewed defense counsel's various media interviews following the defendant's arrest. Similarly, information in one of the cited articles attributed to a Miami-based DHS officer in the aftermath of the March 2024 searches include the following. We believe that there is a disturbing history of sex trafficking. We are responding to concrete, detailed, explicit allegations. This is not random. We didn't choose his name out of a hat. We had allegations that we're following up on. We became aware of certain allegations during the course of the civil suits against Mr. Combs. You have to understand that we didn't just decide on a whim to search his homes. A federal judge had to sign off. This isn't a witch hunt. These statements need to be attributed to anyone even remotely associated with the investigation. They could have come from anyone in law enforcement with a general understanding of how search warrants are executed, who have interviewed the victims and pays attention to the news. That is particularly true here, where there were multiple publicly filed civil lawsuits detailing sexual abuse and trafficking claims against the defendant, which garnered significant media attention well before the searches took place on March 25, 2024. This goes for the alleged federal law enforcement source who is involved in the investigation as well, who on October 2024 evidently reviewed descriptions of videos allegedly depicting sexual acts involving the defendant obtained by the media. The source is quoted as saying, "These are consistent with the videos we have, and just about everything you can imagine was happening at his parties." Again, these statements cannot automatically be assumed to contain non-public information or to be attributed to members of the prosecution team, as the government has made detailed public statements about video evidence that it has in its possession. Indeed, when the alleged law enforcement source made these comments, the government had already described much of its evidence, including that it had videos of freak-offs during 2 well-publicized bail hearings. Across all cited articles, there appears to be only one source plausibly connected to the investigation at all, a purported DHS officer who claims to have participated in the search of the defendant's Miami home. Much of the information this source discusses was a matter of public record at the time he or she made the comments on September 2024. Additionally, while the government agrees with the defense and the court that extrajudicial commentary by law enforcement officers involved in the investigation in any way is inappropriate, those remarks, if made by an agent involved in the investigation or prosecution of the case, are plainly improper. An agent who merely participated in a search, who had no access to grand jury materials, or even the affidavit setting forth probable cause to search the defendant's Miami house, is decidedly not a member of the prosecution team. Moreover, as described above, nothing disclosed by this alleged DHS source was protected by Rule 6E. For all these reasons, the defendant has not made a prima facie showing that matters occurring before the grand jury were leaked, nor has he shown that members of the prosecution team leaked them. 4. The defendant is not entitled to the remedies that he seeks. Because the defendant cannot make a prima facie showing that any grand jury material was disclosed, much less that the source of the disclosure was an attorney or agent of the government covered under Rule 6E, he is not entitled to an evidentiary hearing. See Rio 97 F.3d at 662. Affirming denial of a hearing where district court found relying on evidence provided by the government that no prima facie showing has been made. Here, the only specific alleged grand jury material the defendant cites is CNN's Intercontinental video, which is demonstrably not grand jury material. The defendant is not entitled to a hearing. The defendant seeks an order forbidding the government and its attorneys and agents involved in the case from leaking any further information to the media. This request is moot given the court's order underscoring the parties' existing responsibilities under Local Rule 23.1 and FedR Crim P.6e. As set forth, supra, the government has transmitted the order to all attorneys and staff working on the case in the USAO NY, as well as HSI NY case agents and supervisors with explicit instructions to disseminate to all HSI agents and officers, including those located in other field offices who have participated or assisted in the investigation. Accordingly, the defendant's request for such an order is moot. The defendant's further request for other extraordinary remedies, including discovery, suppression of evidence, disqualification of witnesses, and even dismissal of the indictment, should be rejected out of hand, given that he has failed to make a prima facie case for a violation of Rule 6E. See Nordlich 2018 WL 6106707. At 6. Rejecting the drastic remedies including discovery and dismissal of counts in the indictment as unwarranted under circumstances here. When defendants fail to make prima facie case, a violation of Rule 6E, Scalos 2015 WL 6159326 at 12, defendants have failed to make a prima facie showing of Rule 6E violation and therefore are not entitled to discovery or a hearing on this issue. 2. The defendant is not entitled to a bill of particulars. By seeking a bill of particulars identifying victims under Federal Rule of Criminal Procedure 7F, the defendant attempts to pervert the federal rules of criminal procedure to unduly and prematurely restrict the government's proof at trial, and to co-opt the criminal proceeding to defend himself against complainants in separate civil litigation. The court should reject this misuse of Rule 7F, particularly in light of the serious risk that identification of victims poses in this case, which, as the court is aware, involves serious allegations of violence, sexual violence, witness intimidation, and obstruction. A. The applicable law. A bill of particulars is not a general investigative tool, a discovery device, or a means to compel the government to disclose evidence or witnesses to be offered prior to trial. The proper purpose of a bill of particulars under Federal Rule of Criminal Procedure 7F is to provide a defendant with information about details of the charge against him, if this is necessary to the preparation of his defense, and to avoid prejudicial surprise at trial. Factors courts weigh when considering whether a bill of particulars is necessary include the indictment's text, as well as discovery and other information that has and will be provided to the defendant concerning the government's allegations. Moreover, it's well established that a bill of particulars is not a discovery device and should not function to disclose evidence, witnesses, and legal theories to be offered by the government at trial or as a general investigative tool for the defense. Similarly, a bill of particulars is not designed to obtain the government evidence or restrict the government's evidence prior to trial. Indeed, the limitation on the availability of a bill of particulars is important, as a bill of particulars confines the government's proof to particulars furnished and therefore can restrict unduly the government's ability to present its case. When a defendant seeks victim identities through a bill of particulars, courts generally deny disclosure if the government sets forth specific reasons why such a request should be denied. In particular, courts routinely reject requests for victim identities in cases involving crimes of violence and racketeering, especially when the government demonstrates a risk to witness safety, the potential for witness intimidation, or subornation of perjury. Courts also routinely deny requests for bills of particulars containing victim names on the basis that these requests are in reality a backdoor attempt to obtain a list of witnesses whom the government intends to call at trial. Consistent with the limited availability of a bill of particulars, prior to a filing motion for a bill of particulars, the defendant must comply with various procedural requirements. Rule 7F provides that the defendant must move for a bill of particulars before or within 14 days after arraignment or at a later time if the court permits. Fedar Crim P7F. Further, Local Criminal Rule 16.1 requires that the defendant confer with the government to resolve the issue in good faith and file an affidavit so certifying at the time the motion is filed. If a defendant does not comply with these procedural requirements, the motion should not be entertained. B. Discussion. 1. The motion fails under Local Criminal Rule 16.1. As an initial matter, the defendant has not met the procedural requirements of Local Criminal Rule 16.1, and the motion should be denied on that basis. After sending a letter to the government on October 7, 2024, demanding, among other things, that the government identify its victims, defense counsel alerted the government on October 15, 2024, that they intended to file a motion with the court for the disclosure of victims' identities. The government promptly requested to confer before the motion was filed, as required by local rule. That afternoon, shortly before the motion was filed, the parties conferred, and the government informed the defense that it was aware of no legal authority for the disclosure request but invited defense counsel to provide it for the government's consideration. The government further stated its position that any such request for disclosure was premature before discovery was completed. Defense counsel did not offer any legal authority, but instead informed the government it would proceed with filing the motion. Shortly thereafter, the defendant filed the motion without an affidavit regarding its efforts to confer with the government, in a good faith effort to resolve the dispute. See Local Crim R 16-1. Because the defendant did not adequately attempt to resolve the dispute short of court intervention, the motion for a bill of particulars should be denied as premature. 2. Defendant is not entitled to a bill of particulars. But notwithstanding the defendant's procedural failure, the motion also fails on the merits because there is no need for a bill of particulars listing victim names here. The defendant has been more than sufficiently apprised of the nature of the charges he faces based on, inter alia, the 14-page speaking indictment, government's written submissions and factual proffers at 2 separate bail hearings, the discovery produced to date, totaling over 25 terabytes of data, including detailed search warrant affidavits laying out details of the government's investigation and evidence. Courts have repeatedly rejected requests for bills of particulars where the defendant has received similar materials. In particular, the discovery in the case counsels against a bill of particulars, while the defendant argues that the anticipated volume of discovery underscores the need of a bill of particulars. Courts in this circuit routinely deny motions for the bill based on a mere fact that the case is complex or discovery is voluminous, especially in situations where the defendants have had, or in this case will have, many months to review said discovery before trial. Moreover, the government stands ready to meet and confer with the defense to assist them in reviewing the discovery, a request that the defense has not made. The defendant, backed by 4 prominent law firms with veteran trial lawyers and support staff, cannot credibly claim that he does not have the resources to review these materials within the time he chose to mount a defense. To the extent the defendant claims the time before trial is insufficient to make use of the disclosures he has, the appropriate relief is to ask for an adjournment of the trial date he requested, not to obtain a bill of particulars. In sum, the defendants claim that there is no way for Mr. Combs to determine who the other identified alleged victims are rings hollow. The indictment, along with the other disclosures, including discovery, adequately advised the defendant of the criminal acts of which he is accused and, accordingly, of potential victims. This is particularly true here, where the defendant is not likely to be surprised by the identity of victims whom he may have never met. To the contrary, the victims are individuals whom the defendant is alleged to have trafficked, violently assaulted, and transported across state lines for commercial sex, among other criminal acts in which the defendant directly participated. The Second Circuit's decision in United States v. Davidoff, on which the defendant relies in this motion, provides with no support. Unlike in Davidoff, where the defendant sought the identities of victims in uncharged acts of racketeering, the defendant here seeks the identities of victims of the charged offenses that are outlined in detail in the indictment. Moreover, to the extent that the government extends to introduce evidence of conspiracies or criminal acts other than those alleged in the indictment, such evidence will not be sprung upon the defendant at trial. As its usual practice, the government will file a Rule 404B notice sufficiently in advance of trial. The government will likewise disclose to the defendant at least 15 days prior to trial any witness testimony or other evidence it intends to admit under Federal Rule of Evidence 413. Separately providing the names of victims to the defendant now on a bill of particulars is not required. 3. Any motion for a bill of particulars is premature. In addition to being unnecessary given prior disclosures, the request is also premature because of additional anticipated disclosures concerning the victims in this case. First, as the defendant is aware, the government will produce additional index discovery over the next few months pertaining to the victims of the offenses. In similar contexts, courts have denied motions seeking the identification of victims before the close of discovery. Second, consistent with the practice in this district, the government will file an enterprise letter sufficiently in advance of trial setting forth the specific acts of conduct underlying the racketeering conspiracy charged in this case. That letter will contain more particular notice of the specific objects of the charged conspiracy, including to the extent possible the times, dates, places, and participants for each act. Finally, the government will produce the defense a list of trial exhibits, a witness list, and Janks Act material reasonably in advance of the trial. There is thus no reasonable risk that the defendant will suffer unfair surprise at trial. 4. The motion improperly seeks to restrict the government's proof and poses serious risks of obstruction. Because the government has more than met its obligation to sufficiently advise the defendant of the acts of which he is accused, it is plain what this demand for a bill of particulars really is: a thinly veiled attempt to restrict the government's proof at this early stage in the case and to hijack the criminal proceeding so the defendant can respond to civil lawsuits. This demand should be squarely rejected, especially in light of the risk it poses to witness safety. A bill of particulars is improper due to the nature of the offenses charged. Disclosure of victim names poses serious risk based on the nature of this case, where the defendant is charged with engaging in a wide range of racketeering acts involving violence and threats of violence and obstruction of justice. The government should not be required to produce information that would, in effect, provide the defendants before trial with a preview of the government's case and its victims, with all of the attendant risks to such disclosure. Discovery in criminal proceedings is not comparable to discovery in civil proceedings because the nature of the issues, the danger of intimidation of witnesses, and the greater danger of perjury and subornation of perjury. As this court has observed, the stakes in a criminal case are high, and temptations of perjury, subornation, and intimidation are ever present. Accordingly, the government is not required to turn over information that will permit a defendant to preview the government's case and tempt him to tailor proof to explain it away or see it that the government proof is not presented. Those concerns are particularly relevant in a case like this one, with serious, well-supported allegations of prior attempts to obstruct and tamper with witnesses. Courts thus routinely deny requests for victims' identities in racketeering cases when the government demonstrates a risk to witness safety, the potential for witness intimidation, or subornation of perjury. F.SUPP 2D at 479, denying a bill of particulars for identities of unnamed victims because under these circumstances, and especially given the aforementioned concerns, the gang's reputation for violence, it would be inappropriate at this time to order the government to disclose the names of the intended victims of the murder conspiracy. For example, in Kelly, the district court rejected the defendant's request for a bill of particulars disclosing victim identities in a case involving racketeering and Mann Act charges because based on the defendant's history of obstruction, intimidation, and witness tampering. Here, as detailed in the indictment and at bail hearings, the defendant has a significant history of violence and obstruction. Indeed, Judge Carter found by clear and convincing evidence at the conclusion of the second hearing that defendant is a danger regarding obstruction of justice and witness tampering and is a danger to the safety of others in the community more generally. Due to the defendant's history, the government has serious concerns about victim safety and the possibility of witness tampering if a list of victim names were provided to the defendant. B. A bill of particulars would improperly restrict the government's proof at trial. The defendant's request would also have the effect of improperly foreclosing the government from using proof it may develop as the trial approaches. Relatedly, the defendant's request for victim names should be denied on the basis that it is tantamount to a request for early disclosure of the government's witness list, something he is clearly not entitled to at this extremely early stage of the proceedings. In this circuit, there is a strong presumption against compelling pretrial disclosure of the identity of government witnesses. Thus, such a request should be denied in the absence of specific showing that disclosure of a witness list both material to the preparation of the defense and reasonable in light of the circumstances surrounding the case. No specific showing has been made here, and therefore the defendant cannot overcome the general presumption against requiring early disclosure of witnesses. Moreover, early disclosure of witnesses is especially unwarranted here, where there are serious concerns of witness safety and obstruction. C. Rule 7F is not a vehicle to respond to civil litigation. Even more unavailing is the defendant's argument that he needs victim identities so he can respond to allegations made in civil suits. This court should reject this blatantly improper request. As previously noted, the proper purpose of a bill of particulars under Federal Rule of Criminal Procedure 7F is to provide the defendant with necessary information about the details of the criminal charges against him. It's not, however, a backdoor to obtain information from the criminal case so the defendant can use it to defend himself in the media against allegations in civil suits. As the defendant well knows, there is zero legal authority for his attempt to co-opt his criminal proceeding to defend against civil litigation. The court should thus reject the defendant's inappropriate request for a bill of particulars. The defendant victim's gag motions should be denied. The victim's gag motion should, like the bill of particulars motion, be denied as a premature request for the government to identify and restrict its witnesses and its list over 6 months before trial. Although styled as a request to prevent prospective witnesses and their lawyers from making extrajudicial statements that substantially interfere with Mr. Combs' right to a fair trial, Victim Gag Motion 1, the reality is that the victim gag motion is simply another way to get at the relief sought in the bill of particulars motion, premature disclosure of the government's witnesses, and restrictions of the government's ongoing investigation. The authority cited by the defendant as giving the court the authority to issue such gag order derives from Local Criminal Rule 23.1, which applies to witnesses and attorneys for witnesses in the criminal case. In other words, for the defendant to get the relief he seeks, the government would be required to identify its witnesses to the defendant and the court 6 months in advance of trial. Not only would the government compilation of such a list at the outset of its case, and while it's continuing to investigate, be a fool's errand, but such relief would be unprecedented. Further, the defendant does not even begin to attempt to make the specific showing required for an early witness list. See Bajaza 904 F.2d at 139 and 140, and fails entirely to address witness safety concerns in a case where those concerns are paramount. In the alternative, to the extent that the defendant seeks a blanket gag order that would prohibit any civil claimant and their attorneys from making extrajudicial statements, such an order would be even more extraordinary and beyond the purview of the local rule of which it relies. Indeed, as to the universe of civil claimants, the defendant has specific relief available to him outside the present criminal case. To date, cases alleging sexual misconduct against the defendant have been filed in state and federal courts, including several in this district. These cases were filed before the indictment in the present case as well as after. Those cases are presided over by capable and experienced judges who are free to assess whether any sort of gag order is appropriate and to fashion remedies, including remedies pursuant to Rule 3.6 of New York Rules of Professional Conduct, which mirrors Local Criminal Rule 23.1 and applies to attorneys in civil matters as well. Finally, the defendant's suggestion that the government has directed or authorized prejudicial, extrajudicial statements by counsel for civil litigants is baseless and provides no support for the relief he seeks. The government understands its obligations under Local Criminal Rule 23.1, as it has represented multiple times on the record and is set out above, fully commits to complying with those obligations, as well as this court's orders. Conclusion. For the reasons set forth above, the defendant's motion should be denied. This was signed by Damian Williams, and it was dated October 30th, 2024. All of the information that goes with this episode can be found in the description box.